pleasure to welcome our Director, Sri Gopalappa, and our Deputy Director, Sri Bharat Kumar. I also welcome our resource person, Sri Arijit Mitra. He is the founder member and Honorable Secretary to Ayushman Initiative for Child Rights. That's AIFCR. I also welcome Akshata Sharma, legal advisor for Ayushman Initiative for Child Rights. I also welcome all our mediators of Karnataka Mediation Center, and I welcome all the registrars of High Court of Karnataka and all the and Kalburgi and Dharwad bench also. I welcome all the mediators from Kalburgi and Dharwad, and also all the district and taluka mediators, mediation centers, mediators from all the mediation centers. Now, I request our director to hand over a bouquet to a resource person as a token of gratitude. I now request our deputy director to hand over, to present a bouquet to Akshata Sharma. Thank you, sir. Now I request our resource person, Sri Arijit Mitra, to speak on the subject child access and custody guidelines with parenting and parenting plan, shared parenting. Thank you, sir.
Okay. You can parent a child even without having custody of the child. So what we are promoting here is a shared parenting concept where the child is not getting semi-orphan from one of the parents. So why? Because since in our act, shared parenting is not a law. Therefore, most of the judges, the honorable judges, are not giving any orders of shared parenting, which they should normally give in all cases, except where we find that one of the parents might be abusive to the child. Now, if the parent is not abusive to the child, lot of interjections and lot of accusations can come into the court. But unless you are giving proofs, or unless that is being proved and established in the court of law, we believe that no child should be deprived of the love and affection of any one parent. And the apex court in a lot of cases recently, starting from 2017, this is not the PowerPoint, it will happen. So in most of the cases, the Supreme Court has said from 2017 itself that a child should not be deprived of the love and affection of each parent. So now what we are seeing here is in more than 90% of the cases in custody issues, the child is being deprived of one parent, and the normal thumb rule of visitations being given is say around 2 to 4 hours, maybe per week. In many cases, we see in alternate weeks. So how does that parent, which we call as the non-custodial parent, how does he parent the child? And in that case, I don't think the full welfare of the child is done at all. So now there is the role of the mediators. As I said, say, if you look at the screen, you'll find the guidelines emphasize the mediator and the counselor's role as very important. It's very important and very sensitive to all these cases before they come to the court. I mean, when they are getting adjudicated, because first they are filed and they are being sent to the mediations. So the guideline emphasizes that these mediators, the learned mediators and the counselors, will be the primary facilitators of the parenting plans. Now, if you go through the guidelines, which is available in the website, you will find there's a parenting plan which the guideline has said has to be compulsorily submitted by both parents, along with an affidavit, which is called the child custody affidavit. I'll come into that later. So, here, the most important role of the mediator or the counselor would be to ensure that your client or whoever comes to the party comes to the mediation table, they are given a time to prepare this parenting plan. Because unless you have a parenting plan, how will you convince the other person what care you will take of the child? So that is the basic objective. Now, what is the time span? The guideline says that once the summons are issued to the other party, then within 7 days of the issue of the summons, or within 7 days from the first day of mediation, that is the first time frame, you should submit and prepare this parenting plan. Why it is this being done? Because the guideline wants to achieve one benchmark, that within a period of 30 days, some reasonable access order is given to the non-custodial parent. Instead of the cases running into 3 to 4 months, in some cases 6 months, even we have seen cases where 2 to 3 months, 2 to 3 years have gone without a single access order being passed by courts. This is not justice and this is not welfare of the child. Therefore, the first point that the mediators have to keep in mind is, please try to see that a parenting plan takes place shape in 7 days from the day that the file comes to you and you've started your mediation. And that parenting plan, after being approved by you along with both the parties, goes back to the court. Now, there will be a lot of instances where the parties will not agree to a one parenting plan. So, where the parties fails to agree, it is hoped that the mediator steps in or the counselor steps in and draws up a mutually agreeable parenting plan which can be accepted by both the parties, and it is then referred for an order to the court. Now, it is heartening to know that after the guideline came out in Karnataka, I know of at least 2 or 3 custody matters where the parenting plans have been submitted and they are now in the offing. So I presume and I hope, see, every system needs time. So I hope and presume that within 6 to 1 year, we will see some sort of a change in the process and the whole entire system by which the custody matters are being adjudicated in the courts and how the mediators are being able to felicitate this. So that is the most important point. Second is, as I said, the whole custody matter, we are trying to end that in 90 days. Why? Because otherwise, as I said before, the child gets deprived of the parent. And therefore, if he gets deprived of the parent, then the whole welfare, the paramount welfare, as we call it in jurisprudence, is not assured. So therefore, we expect that in 60 to 90 days, now this 60 to 90 frame apparently seems to be an utopian thought, because this will require a lot of judicial reforms in the way the cases are adjudicated in the courts because of too much work pressure. We often find and the common people saying that it's taking too much time for cases, but then the honorable presiding officer, the learned presiding officers cannot cope up with so many cases being filed every day, and just custody matters are just one of the personal laws that they are dealing with. They're dealing with a lot of every sort of cases in the courts. So this will require the government of India to also step in, which we are trying to do so at the our level from in the center. That some judicial reforms and judicial process are needed, for which we have also approached the Supreme Court. If something can be done on these lines. So now I will come to the basic features of the guidelines. See, the basic features, what is the difference? What is the guideline trying to aim? Previously, we were trying to use the child as a pawn in our battles to settle our egos. By us, we mean the parents who are coming to the courts. So using the child as as a batter to bargain our own interests. We are forgetting the interests of the child. But what is the UNRC saying? The UNRC is the UN Convention for the Rights of the Child, to which India is also a signatory, and the whole jurisprudence is following that broad principles of the UNCRC fundamental rights of the child. And as I said, under one article of that is Article 9 of the UNCRC, it is said that the child has the inherent right to the continuous presence of both parents. Now, what happens in very common thing that all the mediators and the counselors face is some parent is coming and saying, I do not want that the other parent should have access to the child. Why you are insisting on access to the other side? He is this and he is that and all that stuff. But see, whatever relationship the other parent has with the uh, that parent has nothing to do with the relationship with the child at all. And therefore, we believe that from the initial inception, unless you find prima facie that that parent is abusive, how will you know? You will have to rely only on the stories that has been put in. That should not do. The stories must be substantiated by evidences. If that is not there, then you should aim at a reasonable access to the other parent at the beginning itself. Now, what should be that access? That guideline says inside the visitation schedules that at least minimum of 3 hours per week access should be given to that child. That is 12 hours in the month at least. That's the minimum. So that does not debar you from giving more and further access to the child. The guideline also prefers initially to give overnight access wherever possible to facilitate and to promote and to encourage overnight access. Because if you do not have overnight access to the non-custodial parent, how is that parent be expected to take care of a responsibility? Just giving money and giving maintenance to the child is not parenting at all. So that has to be actually invoked upon, and that is the role that you'll have to take on and to influence and to encourage the other parents to do so. Now, as I said, I was talking about that 7-day thing that is given this timeline, the procedural timeline securing immediate access of the child. So these are all there in the guidelines. When you go to the guidelines, you will get inside. Everything is there. That's day one is the phase one, which is the service of the summons or the initial counselor meeting that is happening. So within 7 days, you are supposed to ask them to give that plan and according to and also the child custody affidavit. I'll show a format of that a bit later. Why? As I said in the bottom left, the delay breeds alienation. Now you should know the child's mind in most cases gets poisoned or gets influenced by the other parent. So to stop this and to minimize this negative impact on the child, because it has a negative mental effect on the child, which is called parental alienation. I think all of you definitely know. So this is a very serious phenomena, and no amount of medical science actually can get that child back to normal self. Actually, if he is very terribly alienated, and I also I'm working with demands also, and they have not been able to actually give me one or even one single case study where they have counseled the child and been able to bring that child back to the normal self. No, they might have got 50 to 60% of the recovery done, but definitely not 90 to 100%. They could not. So that is a very serious repercussion on the child, which everybody of us should actually have at the back of the mind when we are dealing with this subject actually. And this is actually the main the reason why we have taken this up as an objective in our trust, and this trust only deals with these type of problems. So as I said, I was talking about the PS. I'm not going through what the extent that the PS does. You will get everywhere in the Google also. It's a very academic thing. Now The clinical interventions is now the clinical interventions. There's another factor. Now the guidelines has given the privilege and given the opportunity to the mediators and the counselors to refer to psychiatrists or family therapists if they feel like, subject to, of course, the consent of the concerned presiding officers. That has to be recommended in your reports by using Section 12 of the Family Courts Act. And if conditions, merits, and warrants, then such help has to be taken for the purpose of dealing with the mental state of the child. So that is very important. And for how do you understand that? To understand this, you will have to understand whether the responses that the child is giving to you, to your counseling and to your interactions with the child, is whether the child is speaking normally from his usual self, or the child is tutored and is speaking in somebody else's voice. That is a very difficult analysis to and an analogy to make. But that is a very important factor that helps in determining whether the child is influenced, the child is tutored, or the child is under effect of somebody else. And that is a very important point that the mediators and the counselors must definitely keep in mind. There is a this is the standard parenting plan which is given in the guidelines, which is compulsory to be submitted to the courts. Now, this has a residential schedule, decision making of day-to-day basis, and the long-term decisions, the financial support, which parent will support the child in what way, and the dispute resolution mechanism, which is the role of the mediators. Here, if they are not been able to agree, how you can resolve the differences. S- So now is the rights of the children and the right of the parents. So when a case is coming to you, sometimes not only a secular custody case comes to you, sometimes matrimonial dispute comes to you, like divorce cases, like DVs, everything comes to you. So you'll have to understand that when you are looking into the rights of the parents, you must segregate the right of the parents from the right of the child. And yes, you may find there could be tangible reasons where you find that one partner has been abusive to the other partner, continuing to abuse the other partner. Yes, it can happen. But you have to realize that abusing the other partner may not necessarily be abusing to the child. So the child should not be deprived of the love and affection of that abusive parent. That is what we are saying. So the remedial, what is the remedial measures then here? The remedial measures, therefore, we are suggesting is co-parenting and shared parenting, provided even shared custody. Some of the time, the child stays with the other parent, and the other part of the time stays with the other parent. Now, all the G7 countries have already have adopted these shared parenting as a law in their acts, but India has not done yet. The Law Commission has already recommended that in its report of 257 way back in 2015, but it is lying in cold storage with the Ministry of Law and Justice. So we are also making some efforts over there to try and see that it's taken up for debate in the Parliament, and if possible, to reform the Guardian and Wards Act of 1890, which is a very ancient act, in fact. So this is how the ecosystem will work. If somebody wants, or I can share with sir a copy of this presentation that I'm giving. So you all can pick it up. It's free of cost from sir's office anytime. I will make some arrangements for some quantities to be kept over there. See, this is the counselor proactivity. Why we are calling proactivity? Because see, the common matrix here is the child welfare and stability. A lot of things will depend on the role that you play here. Because if you're able to uh, solve even 40% of the problem that is coming to you in particular cases, a considerable amount of time will be saved in the court, not only in terms of adjudication of the cases, but also substantial amount of time in will be saved by the child and for the child, because he will get quicker access to the other parent, and that will also heal whatever alienation or whatever uh, I would say whatever influence that the child is having from the other parent. It will gradually diminish, because actually the only medicine that the child has to get over this mental trauma that the child faces is a normal relationship, the normal relationship of the child with the father and the mother. I'm not talking about the normal relationship or reconciliation between the father and the mother. It may not happen. In most cases, it doesn't happen. That is why it comes to the courts, in fact. So this has to be, if you can ensure this, and that is what we are trying to do, that if we can ensure the stability of the child at the initial stages of any type sort of a litigation, including divorce cases and also including the child custody cases, then the child gets saved. His mental trauma is reduced. And that should be the initial objective of the counselors and the mediators here. So I just share one format before I end my discussion. So this is basically the child custody affidavit, but this is in a graphical form we have made. You will find it a tabular form in the guidelines. Now, what is the difference between this affidavit and the affidavit that you find in section 125 of Rajesh and Neha? The difference is here. In this affidavit, we are asking both the parents to fill in all the parameters, what role they have played before they came to the court, what role they are playing after they have come to the court. So that will give an insight to the mediators also, the counselor also, and also to the presiding officer in the court, is which person is speaking what. Because sometimes they will come to the court and say, don't give access, don't give custody. He didn't do anything for the child. He doesn't do anything of the child. He is this and that and all that stuff. But we have ensured, let that be in an affidavit form at the beginning of the case, so that people get an, whoever is dealing with the matters, get a fair idea of the role that the parents have played in the child's life and what they are now playing. Because we have seen sometimes what happens is when the separations take place and the court proceedings are going on, then one parent suddenly stops supporting the child. He will still want the child. He will still fight for the custody. He will still say that I'm not getting access, but he will not pay for the child at all, because he thinks paying for the child is in other way trying to support the other partner, which is absolutely wrong and amiss. It's a very wrong way of looking at things, because the child is ultimately yours. So you should actually pay for the child irrespective of where the child is living, because the child is not at fault. He has not voluntarily walked out of your house or not walked out with the other parent. So we have ensured that at least you give a undertaking to the court that what you are doing for the child, so that the mediators and the counselors also have a fair idea that either the person is speaking the truth or is trying to hoodwink the counselor and the mediator and also the courts. So there's a format which we fill, you have to fill it. It also includes the investments you have made for the child, if any, and the details are there. And this is also compulsory to be submitted to the court at the time the case is starting. So this is one part of the discussion of today that I have mentioned. So if you have any questions, etc., you can address it to our email and we'll get back to you. And I would now request Akshata, please come in for your part of the discussions. Thank you so much for giving your patient time in hearing.
Okay, good evening, everyone. I'm Akshita. I'm an advocate. Most of you know me. I've appeared before most of you in mediation or against you as a opposite counsel. So, Mr. Arijit has already given a brief introduction of why these guidelines actually had to come into existence. It's because, as a part of the system, when parties go in for litigation, the first thing that everybody wants to fight is for the child. Whether to use them as a pawn, like rightly said, or only for getting some kind of alimony, maintenance, something only for the purpose of harassing the opposite party. Now, these guidelines are gender neutral because in some cases, the custodial parent happens to be the father, and in some cases, the custodial parent happens to be the mother. So it is completely gender neutral. But right now, what I'm going to talk about is your role as mediators, which is very specifically identified in chapter 7 of the guidelines. So as mediators, however, in the entire guidelines, I would want to say that they refer mediators as counselors. But in Family Courts Act or any other place, mediators as such has not been defined. We are always defined as counselors, and all your roles come under that. So now, as your role as a mediator, where does it come into picture? Same thing, it's child centric. Now, whenever parties come to you or it's been referred for mediation, all of us advocates, we come and we want to say, first you decide on maintenance, only thereafter we'll decide on the child custody or child arrangements. But no, this has to have a shift right now, and that is what these guidelines are aiming at. Guidelines basically say, now, boss, you're going to come first talk about the child custody or child arrangement, the access arrangement. So uh, there is a shift. Now we are no longer going to talk about first is not going to be maintenance, first is not going to be alimony, first is going to be the child. And that is what these guidelines are aiming at. Background for this is child requires affection from both the parents. Both of you are part of the process of bringing the child into the world. And hence, the child, you cannot deny the child any affection of either of the parent. You have to ensure as mediators that there is access to the child, even though, I mean, there is a provision in the guidelines. The preface of the guidelines or the introduction of the guidelines does say that when the parties approach the court in either GWC or by filing an application, interim application for visitation, the first thing the court has to do is, before referring the parties to mediation, has to make an arrangement for interim visitation. And if the court is not able to make arrangement for interim visitation, that's where the mediation center comes into picture. Now, before we go on to that, there is a change in terminology now. We are no longer referring visitation rights. We are going to refer it as parenting time. You are no longer a visitor, or the parents cannot be considered as visitor in the child's life. If you are going to have access to the child, you are actually, as a parent, as a mother, what would you do if you have access to the child? As a father, what would you actually provide to the child? A mother will be more of emotional bondage. She may want to give some kind of sensitivity, emotional well-being, some kind of security to the child, wherein the father wants to make the child more confident. So it's more of a parenting time because it's more of a teaching process. Then we have sole custody. All our GWC matters, we want sole custody. We want sole custody. We want to be appointed as a sole guardian. No, now it's going to be shared and co-parenting. That is the aim of the guidelines. You may have the physical sole custody of the child, but you have to embrace the concept of shared parenting, that I am going to be equally involved in the child's life. It's no longer winning, losing. Come on, your child is your child. You cannot have a win or a lose over here. It is always your battle is going to be in the best interest of the child. This was already put up by and explained by Mr. Arijit. Now, what the guideline prescribes is, after the service of summons and your first appearance to the court, your first appearance after the summons is being served, the court has to draw up an interim visitation, some kind of access that you have to have with your child, because you would have been separated for couple of months, couple of weeks, and there's a complete detachment. That is the court's responsibility. Now, immediately on your first appearance before the court, the matter gets referred for mediation. So your first appearance before the mediator on the assigned dates, within the next 7 days, an interim parenting plan has to be drawn. Now, the parenting plan is already the process, or the entire layout of the parenting plan is already there in the guidelines. It basically highlights how many days per week, how many hours per week, and it is divided. The parenting plan also is divided. So if your child is between 0 months to 36 months, that is 3 years, there is a separate set of visitation or guidelines that can be given to the child and the respective parent who has no custody. And 36 months and above, how the parenting plan has to be drawn. These are just guidelines right now, which basically mandates that this is the bare minimum that you need to provide to the non-custodial parent. So that has to be drawn within a week, wherein the parent has to have continued access to the child. And then we have the 60-day period, wherein the 60-day period, you have to draw up the final parenting plan. I understand a lot of disputes are going to come about, and that is also made provision for, that if in any situation a parenting plan cannot be drawn within 60 days, the matter has to be relegated back to the court with the mediator's report. And anyway, the mediator's report is confidential. Parties are not going to be having any access to it. The same provisions continue. But this is the proactiveness at the mediation center. When the child or the party comes to the mediation center, the first thing that has to be done by the mediation center and the mediators is to draw up a parenting plan. Uh, After the parenting plan is drawn and after at least the child aspect is taken care of, then you go into your uh, resolution of the matrimonial dispute. If there is any chance, which anyway all of us basically aim at, is for somehow resolving the dispute between the parties, that can be attended to thereafter. Now, there are other aspects of this also, wherein the mediators are expected to understand the parties who are coming before them, understand the personalities of the parties, understand whether the parties have tutored the children, figure out the environment that the child will be exposed to. And that all has to be taken into consideration while drawing up the parenting plan. So, this is what the guidelines is basically asking of the mediators to look into and address. The bottom, we have the child's natural responses. I think all of us have gone through the entire drill where we're able to distinguish whether the child has been tutored or the child has not been tutored, and how to break the ice with the child. That has to be concentrated upon to see whether the child really says, I don't want to live with mama, or I don't want to see papa's face. That has to be understood with respect to the gravity of the allegations that have already been made. As and how the procedure for mediation is being followed, all the notes, everything is going continue to remain confidential. There is absolutely no access to the parties. You don't need to disclose unless there is a direction for it. Your rights continue, your legal immunity is always there as mediators, as is always continue to be there. That has not been taken away as from the guidelines. It's again a reiteration in form of a diagram that we have service of summons, your first meeting, we have an interim plan within 7 days, then we have the mediation, and then we have the final plan. So that is there. It's a child-centric approach. Parental alienation is a big thing right now. It's coming more, a lot of more people, because parents are wanting to get more involved with their children. And the court process, all of us know, it's a little delaying tactic wherein either there's an adjournment or there is some vacation and the child is not getting access, or one of the parties is going on appeal once an order of the court has been passed. So this is basically a child-centric approach to just enable the child to continue to have access with the parent. And that is the end of my very short presentation, because Mr. Arijit had addressed a lot of issues already. Any questions anybody has on this topic? Okay, thank you so much for your valuable time. And thank you to the Karnataka Mediation Center, all the mediators who've been participating with us in person as also through VC. Very grateful. Thank you so much. Does anybody have any questions? Anyone? Sir. Yes, sir.
Many mediators come to the director and they to a lot of questions. regarding child visitation.
Please, sir.
It is the wish of the parties. Mediation is a party-centric process. Mediation is a party-centric process where the party refused to allow the other partner to visit the child.
So these guidelines are mandatory guidelines, sir. So if there is a party who definitely wants to meet the child, nothing can stop it. This is a guideline which has been adopted by the Honorable High Court of Karnataka, and these are mandatory guidelines. So if there is a non-custodial parent who wants to have access to his child or her child, the non-custodial parent, it has to be mandatorily followed.
Mediators can pose the questions.
Please, sir. Please, ma'am. Guidelines have been adopted, and the High Court of Karnataka has said that this has to be mandatorily followed. It is being followed. The guidelines have already been circulated to all the district courts wherever the child, the aspect of child is being considered, whether it is family court or the DV court, because under the DV Act also there is access to the child. So in so it has been circulated amongst all the courts, and the courts are implementing it.
I'll just interject. I'll just interject. See, the guidelines are mandatory in nature. The order, if you go through the order, says that shall be followed by all the courts. Now, the thing is that we are trying to make this more permanent. So we have referred it to the rule committee to make it under the High Court rules also. So now they are working on that. Now, what does that mean? It doesn't mean that, say, I as a person will get the same relief and that person will get the same relief. No, we are not talking about the relief as the same. What we are saying is the judges should adjudicate the matters within a specific framework. They should not go beyond that framework. For example, we have seen a lot of visitations even been refused. Fathers are not being allowed to go to school. Mothers are not allowed to go to school. We have seen orders. Those are ridiculous orders. They have no logic into this. They are saying that if the father goes or the mother goes to the school, they'll create disturbance. Let them first create the disturbance, then we will see. Why you are stopping a father or a mother? You can't do that. That's not Article 21 at all. So these are the discussions we want to stop. That is what the guidelines are trying to do. So what we are saying now regarding the following of the guidelines, I talked to the learned principal judge myself. We had come actually one day. He said, suo moto, we are not going to ask somebody to follow the guidelines. The lawyers who are representing the courts, or if people are coming PIP, they will have to invite the attention to us about the guidelines. Now the guidelines are 82 pages. Not all the 82 pages are required by your client. So what specific relief you want, under which clause of the guideline, you will have to put it as a petition to us. Then we will definitely consider this. And depending on the merit of that case, we will either give or not. So we have not taken, this guideline does not take away at all the discretion of the judges. It only makes the judges' discretion more rational. That is what is the aim of the guide.
Sir, one question.
Yes, that's a very good question.
ವಾಲಂಟರಿಲಿ ಯೂಸ್ ಆಫ್ ಮಾಡಿದಾಗ
Correct.
ಆ ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ ಹೇಗೆ ಮಾಡಬೇಕು?
Yes, it's a very good question. But if you take my personal opinion, you should make that observation in your report for the presiding officer to see, and then let him take the decision. Because somebody wants to adjudicate his rights of the child, you cannot force that parent.
Sir,
No,
sir, I
sir,
have a
that lot of mediators prefer not to, to this. You are not writing that entirely depends on your discussion. The other guideline has not said anything.
sir, I have a question. I have a question.
Yes.
Okay. In many cases, we have seen very recently that both the parties, they say, and also where the child is 14 years and above. So he says, I don't want to meet parents. I mean, the one with whom he is not staying. And both the parents also say, yes, we are comfortable because under the circumstances. So under those circumstances, what do you suggest? Because we are making this statement and all the three parties are making that statement, then where do we go?
Ma'am, if I get it right, ma'am, you're saying that if the child and the parents are okay with the fact that the child is not willing to meet one of the parents.
Time these days we are getting those cases,
Ma'am,
and where they specifically say, you mentioned that waiving of the visitation, and father says, I don't want to meet the child hereafter anymore.
ma'am, if the
And child
non-custodial
also says the same thing. Mother also says, all the three parties.
Ma'am, if the non-custodial parent says that they have no interest in seeing the child, then that has to come out again in the parenting plan or in form of some kind of writing that the non-custodial parent is not exercising his rights under the parenting plan at all. He is not going to claim any he or she, the non-custodial parent, is not going to claim any access to the child. Please, please, because the parenting plan which is annexed with the guidelines has to originate from the mediation center, wherein it's a tabular form. How many days would the child want to be with the parent, the mother, or the father, or what decisions the parents are supposed to take for the child, including financial aspects of it. The summer vacation, everything is detailed over there, and that has to be addressed by the mediation center, the mediators. So, if the non custodial parent says, no, I don't want to exercise my right, then it's very crystal clear that the parenting plan has absolutely no use. I mean, there's nothing that you have to fill up over there and just say the parent, non custodial parent, has no interest in the child. Because, ma'am, if the non custodial parent Ma'am, this I'll ask Mr. Arijit to address.
Hello.
I'll address this point.
Sir.
Ma'am, you're quite correct. It is a child-centric thing. You
Sir.
just can't renounce and say that I don't want to see the child. I would suggest in that case, if some parent is saying this, probably the non-consensual parent is saying this, you'll have to go through the background and have a thorough probe into the matter, whether he or she is being coerced into saying this. If so, if there are any back-end stories to this, number one. Number two, if not, then I would definitely suggest that all the three should consult a family therapist. Yes. That provision is there in the guidelines. Therefore, if somebody is saying, I don't want to see the child, it is not proper and that should not be commented upon actually in the report.
Sir, sir, I have a question.
Hello.
I have a question. So until now, as mediators, even when GNWC cases are referred to us, we do not have the powers to summon them or forcefully ask any parent to get the minor child before us. No, under the new guideline, unless some when training classes or some guidance is given to us, and even in the mediation report that we submit, it's only whether the matter is settled or not. If it's settled, the terms of the agreement will be drawn and sent to the court. Otherwise, we just make a note that the agreement.
Yes, I understand. I understand
So
the
therefore,
limitations
no.
of the law.
What is the thing that we are supposed to follow
Correct.
under the new guidelines?
Correct. You are right in that way.
Hello.
Regarding maintenance, when husband is refused to pay the maintenance, father suppose, then mother what she will tell, I won't give the visitation rights.
Ma'am,
That time father also refused to pay the maintenance.
I was talking
Mother
about that.
also leave the
Yes,
visitation
I
rights.
was mentioning about that only in the beginning of my talk. But then nowhere in the law says that maintenance is equated with access. It has nothing to do with it. You mean to say that suppose a beggar on the road, he has reared a child. He doesn't have the right to see the child just because he's not earning enough money. How is that possible? That's a very easy way. That is what I said. That is one of the very easy and the very frequent ways of using the child as a bargain in the tool, whether you like it or not. And that is why we are saying straightway to everybody, whether you are a mother or a father, that's my straight thing. How can you stop a visitation in any circumstances? You show me the law. I'm waiting here. You show me the law.
Sir, you said beggars also will not do it.
Sir,
You said beggars also will not do it. I agree with you. Beggars will make provisions for their children, but it is the high top class where we have people in the IT sector or more. What we are seeing in the courtrooms, they try evading. They quit the jobs. They do many things to do manipulate, not to pay money to them.
Yes, that is
Now,
that is
now see how now you're saying make an arrangement for the parenting plan. Okay, now a father can choose not wanting to meet the
now they will
child.
not.
There is a Supreme Court judgment to that. It's his choice. Now, is it his choice to say I want to
Oh,
meet
now,
the child?
oh, ma'am. Now there is a provision in the guidelines. If you go through the guidelines,
I've seen the guidelines.
so you have to give an affidavit. Then you'll have to give a parenting
Sir,
plan.
not come here, sir. He will sell his property. He will move away. He'll quit his job. How many episodes you want in the family court?
Sir,
Can give
ma'am,
us?
that is the misuse of the law that everybody will do.
Yes, sir. That is the problem we have. On the one hand, you are coming aggressively saying that the parenting plan to be made. Ensure equally the father or the earning member makes provision for the child.
Why are
So
you
the
sticking?
child does not
Yeah,
go
but why
working.
why you are sticking to the quotation of father only? Doesn't
It
mother
could be
earn?
otherwise, sir. The what we are facing in the court is what we are seeing.
Oh, this is becoming now you are raising a gender-ethic issue. I am
Sorry,
concerning with
sir.
the child.
It's okay.
It has to be applicable. It has to be applicable to the mothers as well,
Yes, sir. It is not an issue of he or she.
right?
It's an issue
That is
of
what I'm saying. Now, that is what I want to say. You raise this topic for some other purpose, not for this.
how many mothers have abdicated their children, sir. Let's see the vice
So,
versa
ma'am,
situation. Thank you.
ma'am, in IT industry, most of the mothers and fathers are earning equally well. Talked about the IT industry. I know what is happening.
One question, sir. Father is expired. Okay. The mother, her parents are willing to see. Allah, father parents are willing to see the child. Then mother parents are not allowing to visit the.
That is wrong.
Yeah.
That is wrong, ma'am.
What, sir?
That is wrong. If they are refusing, it's wrong. It is wrong. Galat hai.
What we have to do in
Yes.
that situation? What we have to do? Guardians and Wards Act, the child custody. Majority of the people will file the child custody. The grandparents are also involved in that thing.
Ma'am,
At that time,
if you go through the guidelines, we have said that when you apply for a access time or the visitation time, you should apply for everyone, not only for yourself. It's written over there.
So one very important point that is missing from the guidelines is the enforcement of the visitations.
Very good question, sir. I think you're talking from your experience, so much experience. That is a very gray area, sir. We have made some provisions, but I don't know how the courts will enforce it. It's entirely on the courts.
Rajneesh
They seem
versus
to be
Neha.
helpless.
Rajneesh versus Neha gives the enforcement because it is available in the law. But so far as these child custody guidelines are there, the enforcement becomes tough because the learned judges also, who have gone through the guidelines meticulously, they say that there is no provision for enforcement of this visitation.
Sir, it is there in our guidelines. Especially, I think, which page is that? I think in page 5 you will find, if I'm not mistaken.
Sir, in one case, father had sought the custody of the son. Mother says, my son is not. Mother says the son is not willing to go and join the father. And the child was brought. He also says, I do not want to go to the father. What is the role of?
So that is what I said, that you should encourage that they should go to all the parents. It should be encouraged that they should go to both the parents. You have to make them understand that you're wrong. But that is a limitation to the mediation, but that is not there in the law. Sir, yeah, have you got it?
So respectfully, in page number 5, it talks about punitive measures if the visitation guidelines are not followed, including change of custody. But for example, if I need to take any assistance from the police, for example, those things are not mentioned also in
Yeah,
the.
because that is because we also do not prefer police action in child matters. But if there is continuous contempt, then of course you will have to take it. I think in India, 3 or 4 cases have happened when police have been given the power to change the custody. I mean, to pick up the child. But I think the most easiest way would be to ask the presiding officers to bring the child to court and hand over to the other party in front of him. Otherwise, you have to enforce contempt, but the contempt the courts will not enforce.
The courts have, yeah. Anyway, thank you. Thank you.
Yes.
Sir, I want to ask you one.
Ma'am, that is very wrong. Very wrong. If you change the circumstances, even after we are grown up, if we go to a new circumstances, suppose I get a new job somewhere and I go to some other place, I will stay there for some time, I will get acclimatized.
Ma'am, so far as the child psychology is concerned, that is addressed in chapter number 6, wherein if one of the parties is basically saying that the child is affected mentally, is being tutored or is scared or for whatever purpose it is, the chapter number 6 in our guidelines also makes provision that the parents, if you're making allegation against the parents or the child, they can be sent for psychology assessment. That provision is also made. Please, parents also, the parents and the child go for psychology assessment. Yeah, not by the mediators. See, the role of the mediators is very clearly established. What questions are coming now is probably the agitation and frustration of the clients that are come before you. But your role as mediators is just plain blank with respect to drawing up a parenting guideline, facilitating that the access continues. And if there is an allegation that the parent is abusive, one of the non custodial parent is abusive, there are provisions even for that made in the child custody guidelines.
Hello, ma'am. In some cases, like both parents will be there. They would have been separated for some years, but the child's name's initial will be given by the mother.
Child's?
The child's father's name initial is not been given. The mother takes that right. I don't want to give his initial. What do you say for that?
Ma'am, this also, there is a provision made for that, that when the child is born, normally the tendency is that the surname of the child or the initial, like you're saying, is the father's initial. That provision also is made in the guidelines that so far as a matrimonial dispute is going on, you cannot, the custodial parent cannot change the name of the child. The surname of the child or removing the father's existence or the non custodial parent's existence from the child's life cannot be, what do you say? Uh,
Yeah, I got it. But some mother,
cannot be misused or
yes,
cannot be removed.
now they do, some mothers are doing, we'll change it in Aadhaar card. They don't want to give the father's initial itself. That's
Ma'am,
happening.
you will have to advise the children, you will have to advise the client
We do
that
that.
the guidelines mandates it. And if there's a violation of the guideline, then the court is going to take punitive measures. Though the punitive measures will be at the hands of the court, we'll have to file an application, but the guideline mandates you cannot touch the father's or the surname of the child. If they're doing it, it is illegal. We are all aware of it. Then the respective advocates have to take their stand for their clients by going to court. The guideline just mandates that it cannot be changed.
Thank you.
Any other questions? She has. She has.
Hello, I just want to.
So the normal tendency is then as the grandparents, but that provision has not been addressed in the guidelines. It comes also over there that if we find that both the parents are abusive or both the parents are not, then the next of kin will be in charge of taking custody and care of the child. That provision also is there in the the chapter for mediators at the bottom of the page, because it comes from JJ Act. That if the parents are abusive, then the custody has to go with the next of the kin who will take care of the child.
Yeah.
He's talking
Yeah,
about
one,
the abusive parents. He's talking of the fact that both are voluntary, not wanting to take the. I think maybe both parents want to move ahead in their life. So it should be the extended family members, if not the next of kin or something. But there is provision in the GWA Act. If somebody is interested, he has to apply for guardianship over there under Section 10.
yeah.
Ma'am, if I can just request, I'm sorry, but if I can just request if there are any questions from Kalburgi, Dharwad,
Good evening, madam.
mediators.
Good evening, madam. Good evening.
Good evening, ma'am.
Dharwad bench. From Dharwad bench,
Yes, ma'am, from Dharwad bench.
I'm Anuradha Deshpande, mediator from the Dharwad bench. Practically, am I audible? Am I audible?
Ma'am, your voice is not audible, ma'am. Not able to understand. It's not very clear.
One minute. Good evening, madam.
Good evening.
Am I audible now?
You're audible.
I'm a mediator, Anuradha Deshpande from the Dharwad bench. Practically, there is a case which I have dealt with. So I would like to discuss with regarding child custody on that matter. I had a case for criminal miscellaneous of a cancer survivor whom the husband had neglected. And she had gone for a treatment in Bombay for Tata Memorial. Now she has returned back. She is a cancer survivor. And she filed a GNW only for visitation because she is not able to take care of the child entirely. And in that matter, the husband compromised, saying that he will send the child twice a month to her. But later on, he's not sending her. And yesterday, there was a criminal miscellaneous wherein the family court tried to counsel. And in that counseling, the husband has brought the child, and the child is saying that, no, mommy, I don't want to come with you. I am going to stay with the father. Yes.
Ma'am, your entire question, if you could make it very specific, ma'am, because a long sentence we are not able to get the clarity over here.
Now,
Just
can I put it like this? The mother has compromised in the GNW. The father has compromised, saying that he will send the child twice. That is what enforcement of the compromise, which could not be done. But the criminal miscellaneous is still pending. So, can there be any of these guidelines which you have mentioned be effectively implied in the criminal miscellaneous? Okay.
ma'am, if I can just request you, because there's still a little clarity problem over here. If you could just send us your query in question in the email, I think we'll be able to answer you better. Or at least if there's a chat also available, we can answer you better. Somebody could attend over here.
I'll send a mail.
Ma'am, we'll send out our email address. You could send us your questions on the email because it's only because of the clarity issue I'm not able to answer you right now.
I'll do it.
Any other questions from here? Ma'am, you had a
Yeah, these guidelines are really very helpful to us. I just want to know in mediation, it is a party centric process. Sometimes the husband voluntarily gives up visitation rights or he voluntarily agrees to that his name is removed. So, what can be done in such a case?
Ma'am, see, the guidelines are very well written right now, and it is before the rulemaking committee. These hiccups will definitely be there, but right now we are only concentrating on the child centric. I understand that mediation is party centric, but the guidelines are child centric. All mediation center can do is advise or address this issue with respect to the parties that you have access to the child. Why are you letting go of the child? Like Mr. Arijit had also said, is there something that is already disturbing with respect to the child is going to be with the mother, so why should the father pay? Does he feel that he's being cheated and removed of his money? That core has to be addressed, would be my only suggestion. Please. Ma'am, exactly why is he voluntarily giving up? Whether it is under coercion, we do not know, or whether he does not want to pay for the child because the child is not going to be with him. That has to be very categorically addressed to the parties themselves. That has not been addressed in the guidelines, but that has to be addressed to the parties themselves. Okay, thank you so much for this session. I thank Karnataka Mediation Center for giving us this opportunity to come forward and actually put forward the guidelines, because this is the need of the hour. We, as advocates, as when we are in our advocate professional right now, we are going to fight for our clients. We're going to say that if I'm for the wife, I'll say the child should not be given to the father. If I'm for a father, I'm going to fight for the child. The roles are reversed because we don't know who the custodial, non-custodial parent is. But I think there is a definite need for shift. And we need to make our disputes not the child's dispute. I have to fight with my husband. I will fight with my husband, but I will not bring my child into this picture. That is the whole idea of these guidelines. And Calcutta has adopted, Calcutta has passed it, Karnataka has adopted it. There are a lot of states that are taking this also as in a full force. And we just hope we see the best now. Thank you so much for this opportunity.
Thank you so much, Mr. Arijit and Akshita, for this wonderful presentation. This always has been a big contentious issue, child parenting, custody, visitation. You have, to the best possible extent, clarified our doubts. The more it evolves, the better it will be for the children. Thank you once again. It's been a great learning experience. Thank you, sir, the director, sir, to the deputy director. Thank you to the registrars of Karnataka High Court at Bangalore, to the Gulbarga and Dharwad bench. Thank you to all my dear mediator friends at Karnataka Mediation Center, to the mediators coming in from Dharwad and from Gulbarga. Thank you to our staff. Thank you.